Welcome back, everyone. Today, we're diving into a courtroom drama that's equal parts shocking and complex. At the center, we have Justin Dannon Swank, accused of theft and criminal damage, and Angela Brown, his alleged victim, but also his wife. Yes, you heard that right. This isn't your typical case. It's loaded with domestic complications, mental health factors, and financial stressors. Right from the start, Angela is asking to lift the GPS unit and the no-contact order, which immediately raises eyebrows. Why would the alleged victim request contact? Stick around, because as we unravel this story, the twists keep coming, and every detail matters. Who's really telling the truth? And what will the court decide? Let's jump in.
One, Judge, this is a case where after talking with Mr. Swank, we are asking to have it set for a jury trial. Further, Judge, I would tell the court the named alleged victim in this case, who is Angela Brown Judd, was just in my office. She is wanting to appear here today. We did give her the email for the Zoom link. I don't know if she's appeared in the waiting room or not. I think she wants to appear in reference to a request to lift the GPS unit and also lift the no contact order.
Okay, Jen, have you seen someone identifying herself as Angela Brown Judd, Judd?
I do have someone in the waiting room labeled iPhone. I have sent them a message, but they have not responded.
That's probably her. I'm not sure how good she is at the Zoom stuff, Judge.
Well, you know why we have this rule, Mr. Patterson.
I do. I understand fully, Judge. I don't know if the court wants to put this to the hill of the docket or.
Well, let's take a chance, and I'll have to bear the brunt if it's a mistake to do so. And of course, I'll come back on you, Mr. Patterson, as much as I have to answer. So
all's on me. I understand.
All right. So Jen, take a chance and bring her in. I don't know why they won't identify when they're told to, but. Okay, is Angela Brown Judd present? I'm still not seeing her.
Yes.
Are you?
Okay, that is her, Judge.
Okay, you're Angela Brown Judd, is that right?
Yes.
And you are appearing today as an alleged victim in State of Kansas versus Justin Dannon Swank, is that correct?
Yes, ma'am.
And he is charged with theft of a truck and key rings belonging to you and criminal damage in a value less than $1,000, in which you're the alleged victim.
Yes.
These crimes allegedly occurring April 17th and 18th of 2025. What is it you want to be heard on, please?
Well, I know that
Before you answer that, what's your relationship, if any, to the defendant?
That's my husband.
He is your husband. Okay.
Yes.
Was he her husband on April 17th and 18th of 2025?
Yes.
All right. So go ahead, please.
Okay, so I kind of explained I do have some mental health problems that have been addressed most of my life. The issue with Justin is I acted out. As far as the truck's in his name. He does have the title in his possession. I have a brand new $1,400 iPhone that I'm holding in my hand now. And it was probably more of my fight on dropping the phone. The phone wasn't even worth $100, honestly, when we went and put it in a machine. So, I just don't, the truck's in his name now. It's his possession. I don't know any further. I mean, he is my mental health. He's over me with my SSI, my Social Security.
Here's where the tension really heats up. Angela Brown candidly admits to mental health struggles, explaining that some of her actions, like the damage to the phone and disputes over the truck, stem from her mental health challenges. But she also frames Justin as her caretaker, her payee, her stability. This is a classic example of how personal relationships and mental health intersect with the legal system. And notice her perspective on the ankle monitor. She questions its value, the cost, and its role, essentially arguing it's unnecessary. This raises an important legal point. Courts often weigh victim protection against a defendant's rights. Could her testimony inadvertently strengthen Justin's case by suggesting she might be unreliable? What do you think? Should her mental health disclosures affect the no contact and GPS decisions?
He is
He's
my
what they call
caretaker.
Your payee. He
He's
gets
my
your
payee
money.
and my caretaker. It's my mental health stability. He's been my best friend since 2000. And I think a lot of it was my mental health acting out. And I'm trying to work on that. I've started some new meds. But I put him in a situation that, we barely just bought our house. This ankle monitor's eating up, $300 a month. As I said, I'm on disability.
Excuse me. How do you know how much the ankle monitor is costing?
Oh, trust me, I've been on ankle monitors more times than you probably put people on ankle monitors, ma'am.
And you
So,
haven't talked with him about how much he's paying on the ankle monitor?
no, ma'am. But I've been on ankle monitors probably more times than you've issued it in your courts.
Are you paying for that out of your disability, his ankle monitor?
No, I'm not paying for that out of my disability. But regardless, I mean, disability isn't enough to pay for something like that. But regardless of what it is, I mean, what is the point of an ankle monitor? I don't see whose butt it's saving. Yours, mine, his. What is the ankle monitor doing for him anyway?
Well, before you started talking today, I would have said it's for your benefit, but now it sounds like it's for his as much as for yours. If you're coming on here telling me that you set him up, it was you that dropped the phone and damaged it, and that it was your mental health that caused him to be in this case, that makes it sound like maybe he needs protection from false allegations. If you're wanting to take that route and say these are all false and your responsibility, I'd say the ankle monitor is to protect you both, so you can't later say he came around you if he didn't.
Okay, he needs to be around me. That's my stability, my mental stability. That's how I get to my appointments. That's how you know what I'm saying? I don't function well without him. And I haven't functioned well without him since 2001.
All right, so you're basically here to ask me to lift the no contact between the two of you. Is that right?
Yes.
Now, let's unpack the ankle monitor issue because it's more than a simple tag on the ankle. Angela mentions that these devices cost around $300 a month and stresses her disability income can't cover that. Here, the court must balance financial burden, personal freedom, and protective measures. Ankle monitors aren't punitive. They're meant to ensure compliance with no contact orders and protect both parties. But Angela's argument highlights a tricky point. What happens when the alleged victim challenges the very mechanism that safeguards them? It's a fascinating intersection of law, cost, and human behavior. Would you prioritize protection over financial strain in a case like this?
And whatever else.
And to remove his ankle monitor to keep him in line with this relationship with you. You want the ankle monitor off of him too, right?
Well, I mean, that would make sense. I mean, he's paying for something for what? I just for the benefit of what? There's that an ankle monitor doesn't protect anything. The things that I did on an ankle monitor, you could only imagine. So,
all right, thank you, ma'am. Thank you, Miss Swank. Does any attorney want to be heard on this
Yes,
request?
Judge,
Mr. Patterson, why
Ron.
don't you go first?
Okay. Judge, this is a case where I have spoke to my client. It is a case where we are asking to have a jury trial date set, but also based upon statements of Ms. Brown Judd, as well as my client would ask the court to remove the ankle monitor, the GPS. It is costing a lot of money, and asking to allow the contact and lift the no contact order. Thank you.
This is where the courtroom fireworks start. Mr. Patterson, representing the defendant, requests removal of the ankle monitor and lifting of the no contact order, citing cost and the victim's statements. The state objects, arguing no formal motion has been filed, and the issue isn't properly before the court. This back and forth is a prime example of procedural strategy. The defense tries to fast-track modifications, while the prosecution ensures all formalities and protective safeguards are respected. These moments show how much timing, documentation, and courtroom etiquette matter. One missed form or misstep can dramatically affect outcomes. And for viewers, take note. Even if you're right substantively, legal procedure can make or break your case.
Mr. Regier?
One moment, Your Honor. As a preliminary matter, the state would have it noted on the record that the issue of lifting the no contact or the GPS monitor does not appear to be properly before the court. The state is not aware of any formal written motions have been filed with the court, so I am at somewhat of a disadvantage in this case. If the court is prepared to determine that that issue is properly before the court, the state would object to any modifications in prior bond conditions at this time. This is a case that appears to have multiple counts with domestic violence designations attached to the same. Notwithstanding any statements made on the record, this is a defendant with a history of prior convictions that the state considers relevant. If the court wishes me, I can go into those briefly. But again, the state's position, at least from the offset, is that this issue is not properly before the court, and if the court is prepared to take it up, the state would adamantly object to it.
You object to taking up the issue at this time?
That would be the state's first objection, Your Honor.
Well, I think we're a little late for that because we've already started taking it up. I understand where you're coming from, though, that you're surely perhaps blindsided, maybe not. Maybe the alleged victim has been to your office and made these statements before. Maybe she hasn't.
Your Honor, may I please speak?
One last time before I make a ruling. Go ahead.
I did write a letter to their office, to Miss Sarah Green. I did come in and speak with her again after the incident happened. I do have documentation that, like, a lot of my appointments he is present on. So, I've tried to give them as much information as I can. I've tried to provide them with whatever. I have emails between me and Miss Green. I don't know what else to further say on this issue. He objects.
Not to say anything further, okay?
Yes,
I understand I hear what you're
Yes,
saying.
ma'am.
I don't think you need to keep trying to put it into words.
Yes,
I
ma'am.
will tell you that with domestic violence victims, any of us that have worked with them with very much period of time, we know that even if you don't have an unhealthy mental health background coming into them, they can be very troublesome. They can play havoc with your judgment. And that's why the courts and counsel have the responsibility for setting up measures to try to protect you from what you may not know is involved with what you're asking. And so we put those protections in place for primarily the alleged victims, because we don't go looking for you and your husband to pick on or pull, separate. We get involved because whatever's happened between you has caused law enforcement to become involved. And I'm sure if you go back to the county attorney's victim witness provider, she can explain to you in more detail and better than I can in a short period of time why it's important to protect victims, alleged victims who may not even realize they need protection. That can happen with children, that can happen with domestic violence victims, because they just don't understand everything that's involved. We don't understand everything involved, but if we've been through this enough times with others, we kind of start getting some familiar patterns to deal with. So, first of all, Mr. Regier is right. There isn't a formal motion to modify the bond conditions. Second of all, even if there were, I am not sure that I have from you any kind of safety plan prepared from a safe house or a therapist to show that what you're proposing would be a protective measure. And then additionally, with what you've told me today,
The judge now weighs in, providing some of the clearest legal insight in the case. She emphasizes that protective measures, like the ankle, monitor, and no-contact orders, exist not just to control the defendant, but to shield the alleged victim from potential harm or false accusations. Notice her practical approach. She acknowledges that domestic violence victims, especially those with mental health issues, can unintentionally complicate matters. She points out that even without formal motions, victims have a right to be heard. But moving forward requires proper legal representation. This is courtroom realism at its finest. The law protects everyone, even when relationships are messy. How would you handle balancing victim rights and defendant protections if you were in her shoes?
I would think that the defendant might be afraid of you making false reports on him, that if he comes around you, what's to say he's not going to get the police called on him again and be charged with more and more serious charges even. I don't know which one of you's done something wrong. If either of you, that's for the jury to decide that Mr. Patterson has asked for. They will hear both of your evidence, both of you maybe. They'll hear from Mr. Regeer's evidence, including you or not with you. Mr. Patterson will have the opportunity to present his client if he wants or any other evidence. But that's going to be for the jury to decide. I will grant a jury trial. Jen, when's our next jury trial? I've forgotten.
Pre-trial is February 23rd, Your Honor, with jury trial beginning February 25th.
Now the court sets critical dates: the pre-trial on February 23rd and the live jury trial on February 25th. This is a big deal. The jury will ultimately hear all evidence, including conflicting accounts from both Justin and Angela. Until then, the judge refuses to lift contact without further mental health assessments. This demonstrates the careful pacing courts employ. No shortcuts, even when emotions run high. It's also a reminder to viewers how long legal proceedings can take, even for seemingly small disputes. Every piece of evidence, every testimony, every procedural step will be dissected in front of a jury. This is what makes courtroom drama both legally intricate and intensely human.
February 23rd is pre-trial. February 25th is jury trial. We don't have any in October this year.
Waste of money.
You do have one coming up with pre-trial. It'd be in September 29th. I was just concerned that that would not be enough time to prepare.
That would be the state's
Probably won't.
concerns as well, Your Honor.
Understood. Okay.
Immediate.
All right. So the next available, I will set this Mr. Patterson at the defendant's request for jury trial. I trust you'll be filing appropriate
Yes.
documentation.
Yes, sir.
February 23rd at 9 a.m. will be the pre-trial by Zoom. Actual jury trial will be February 25th, live in person at the courthouse, Mr. Swank. And those are both in the year 2026. Miss Swank will get a subpoena if necessary to be present for that from the state. Okay, so that's the first order of request today, is to set this over for jury trial. The next is, I am not going to allow contact without further mental health experts. And that's not only just to protect you physically, Ms. Swank, but to protect Mr. Swank from any false allegations. I don't know what's right and wrong. I have heard bits and pieces, but the jury will hear it all in February and they will decide.
So what would you like from who?
Well, go back to the county attorney and talk to them more.
He's an idiot.
Or you go hire a witness, you go hire an attorney of your own if you don't think you're getting what you need there. But you see, you have victims' rights, and that's why I'm letting you speak today, even though there's not a motion on file, because I believe that you do have the right to be heard even without a motion on file. And that's why we're taking this up briefly today. But if we're going to take it up any further, you're going to need to get an attorney or go back to the county attorney and let them represent you on this motion. So that's what I'm going to direct you to do. And we can take that up February 23rd or sooner if the parties or an attorney want to ask for an earlier date on that sole issue of bond modification.
So there's no specific thing that you want for the courts from my doctor?
I'm not going to tell you how to present your case. I want you to get with an attorney and let them present their own case.
Wrapping up today's session, the judge makes it clear Angela can speak. But for any formal motions regarding bond modifications or GPS adjustments, she needs legal representation. The judge is protecting all parties while respecting her voice. This is a perfect example of procedural justice ensuring that both defendant and victim rights are preserved, while also preparing the case for an impartial jury decision. Note how even without a formal motion, the court allowed dialogue reflecting both empathy and legal prudence. For those watching, this is a crucial teaching moment. The courtroom isn't just about guilt or innocence. It's about process, rights, and measured decisions.
All right.
Okay. All right, if there's nothing further, counsel, Mr.
From the
McGee,
state, Your Honor.
Mr. Patterson.
Nothing further today, Judge.
All right, thank you all for your time. We'll be in recess at the Swank, and anyone here to just on Swank is excused.
All right, let's recap. Justin Dannon Swank faces charges for theft and criminal damage, while Angela Brown, his wife and alleged victim, brings complex mental health considerations and relationship dynamics into the courtroom. The judge allowed her voice to be heard, but denied lifting the no-contact order or removing the ankle monitor without further legal proceedings. The jury trial is set for February 25th, where both sides will present evidence and an impartial jury will decide. This case highlights the intersection of personal relationships, mental health, and law, showing how careful the courts must be in protecting everyone involved. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.